Welcome to the ninth episode of Beyond Retirement, sponsored by Senior Edge Legal. I'm Susan Graham. I'm a certified elder law attorney based in Boise, Idaho. Today we're going to talk about why young parents need a will. Now, your goal in listening to this program is to gather information and also, I understand, to see if you think I might be a good member for your team. My goal is threefold. One, to give you useful information so you can have a secure future. Two is to provide you with some free legal forms that are available on our website. And then lastly, give you a method to contact me if you think you'd like to have me on your team and talk about your estate plan. There's an evaluation form at the bottom of your screen that you could fill out anytime during this presentation or even at the end. So let's get started. So why do young parents need a will? Well, what happens if you don't have a will? If you have no will and you have children, then what happens when you're both gone is we've got multiple problems. First of all, who's going to be the guardian of the children? Who's going to raise them the way you want, with the values and the morals that you think are important? And then who's going to manage the money for them? You haven't selected anybody, so that's going to kind of be a crapshoot. I had a cousin. Her mother and father died when she was 12, and they'd made no plan. And what happened was, that was very sad. No one knew they were supposed to step up, so no one did. And eventually it became a problem, so finally one of the aunts and uncles stepped up, and then they decided they didn't have the responsibility for her, so they turned her over to another family member. That's just not right. So when you sign a will, what happens is you say, well, when you're both gone, who's going to be the guardian for that child or children? You need a guardian when somebody is under the age of 18. And it doesn't have to be a family member. And I usually encourage people who do these wills to have an alternate in case the first person is not available. Now, when you select a guardian and you say it's going to be Frank and Betty, do you really mean the two of them, or you're only focusing on Betty? So if Betty predeceases you and she's not available, do you really want Frank to be the one raising those children or that child? So you need to name at least one guardian and then a backup to that person. Again, they don't have to be a relative. They don't have to live in town. But the people you're going to select are going to be people who have values and morals and a lifestyle that you think is appropriate to help raise your children. They will be the guardian, the one that makes the health and the housing decisions and the school and medical decisions for those children until they reach age 18. When a child is around the age of 12, and if a guardian needs to be appointed, the court will actually talk to the child and see what the child feels about it. Because definitely the court does not want to have runaway children. But again, if you select the appropriate person, that would be the best arrangement. The next problem about having no will or no plan in place is if you're both gone, the Social Security system will provide benefits to your children. And who's going to handle that money? Again, if you haven't said, you have no clue who that's going to be, and will they handle the money appropriately for those children? I have been appointed by the court in two different circumstances where the parents stole the money from their minor children, and the court appointed me to get the money back from the parents. The problem with that, when people steal money from children, they don't have any money. So in this circumstance, if you're both gone and somebody is appointed to handle the Social Security for your kids, you want to be certain that the money's actually used for your children and it doesn't disappear into somebody's pocket. The third aspect of having a will is if you have life insurance or some other assets when you both die, and many young people have life insurance because it's pretty cheap, and to cover these kinds of terrible contingencies if something happens to the parents. Who's going to manage the money for the children? You haven't said, so again, the court has to try to figure that out. And also, the law says that the children are grown-ups at age 18. Now, my office is 2 blocks from Boise High, and I go through that campus a couple of times every week to go to the YMCA to exercise. And I come back through that campus when the school is let out at 10 o'clock or so for their morning break. And it's quite amazing, the young people that are gathered around in there. Their hair is all kinds of strange colors, and the wardrobes they attire themselves in are quite appalling. So, what the law says, they're grown ups. So, if you hand an 18-year-old $100,000, they think they've just won the lottery. They have no clue about how difficult it is to manage that and how hard it is to hold on to it. So what happens is they just have a free time of spending the money, which is marvelous for them, I guess, but there's nothing left. So most people, when they set up estate plans and they're managed and the money is available for young people, there are studies that say young people don't really get their feet on the ground and pay attention until their late 20s. Basically, they're idiots until their late 20s. So normally what people say is no, they can't get the money at age 18. It's going to be managed by someone that you feel is responsible. And it can be used for schooling, for buying sneakers, for trumpet lessons, for a wardrobe, for down payment on a house, for paying for tuition at school or college or trade school, whatever seems appropriate for that child, and they'd get the balance at 30 or some other time that you feel is appropriate. If they're going to school and they're having more fun going to parties as opposed to going to classes, or they're sitting on the street corner smoking dope, then they're not going to get any money. This is just common sense. You wouldn't be giving it to them, so certainly the person managing the money would not do that either. And you need to name a backup, just again, in case that first person is not available. You can use as the money manager for these funds that are for your children, again, a friend or a family member. You can also use a professional. There are bank trust departments and some other companies that manage money in this manner. They do that all the time. And the advantage of using a professional, especially a bank trust department, is they don't die, they don't move away, they don't get irritated with your kids, and they're insured. So you have the peace of mind that someone is going to be there and do it right. So for young families, for young parents, it's critical that you write a will. Now, among the forms that we have available on our website is a free form that shows you how to make your own will if you don't choose to hire an attorney to do that for you. At a minimum, it helps you determine who is going to be the guardian and the alternate for your children. So a will is really important because it protects your children. It protects them so the right people raise them and the right people manage the money for them, which is, they're your most important assets, so that gives you great peace of mind to have that accomplished. I want you to consider filling out that evaluation form, again, to critique me. That would be very helpful so I can offer programs that you would like me to address in the future and tell me how I can improve. Also, you can access those forms, those free forms, not only the will, but other forms on our website. And if you'd like to make an appointment with me, indicate that and someone will contact you about that. Thank you very much for spending your time with me. The next time we're going to talk about who owns your assets when you're married. Thank you.